Share, Dr. Sullins, and welcome all to this lecture by the Family Research Council with our esteemed panelists. The topic is the Supreme Court and marriage. What happens after the decision? This is one of our online panels. We are being filmed, and we will have time for questions after the panelists speak, and I will just ask you to identify your affiliation, if you have one, at the end. And we have someone with a microphone that will come around to help you ask your question. My name is Kathy Roos. I'm Senior Fellow for Legal Studies here at the Family Research Council. This is my second tour of duty. I've started with the Family Research Council back in the mid-90s, and then took a little break to work on the Hill and other places, and now I am back. And just delighted to be able to bring to you this important panel at this very important time. Next week, the Supreme Court will hear arguments involving one of the most contentious social issues of our modern American history. One side will ask the court to choose winners and losers in the same-sex marriage debate. The other will ask the court to let the people of each state decide for themselves. I'm an attorney with an organization that tops the enemies lists of progressive political groups. It was never my hope or expectation that my professional career would earn me this dubious distinction, though there is consolation in the fact that many other lawyers that I know and greatly respect share it. Our chief offense is that we believe that marriage is exclusively a man-woman proposition. Half of America agrees with us. Many more than half if you count votes rather than survey answers. And those numbers really do matter. We can't be dismissed as outliers with odd views, or something worse. Even the most enthusiastic gay marriage advocate should be loath to attribute base motives to every other American in this country. Throughout history and in every culture, marriage has been set apart from other relationships because of how humans propagate. Not alone, not in groups, not with members of our own sex, but through sexual union with one other human person of the opposite sex. Every person alive owes his life to this simple biological equation. These arguments have been outlined for the court. Religious Americans see in this design the hand of God, and indeed the divine plan for man-woman marriage is outlined in the sacred texts from all the world's great religions. The court has received numerous briefs of what people believe with regard to marriage and why we believe it. Many Americans support man-woman marriage because of the practical benefits that flow from it, namely that children thrive with a mother and father. This is why government is involved in the marriage business in the first place. This is the only reason why. So that men and women will be encouraged to establish stable unions to raise their children for their good and the good of society. The court has been thoroughly briefed on these arguments as well. Finally, there's the matter of the locus of the question. Who decides? The Supreme Court has long recognized the authority of the people of each state to define and regulate marriage within their borders. The opinion in U.S. v. Windsor is replete with affirmations of that principle. The Defense of Marriage Act was problematic, according to the court, because it defined marriage one way, while the plaintiffs who lived in the state defined it another way. That is to say, the state defined it another way. I'll state that again. DOMA was a problem because the federal government defined marriage one way, and the state where the plaintiffs lived defined it another way. That was the problem. To be sure, Kennedy planted the seeds of an equal protection argument in Windsor, and we may see those seeds come to bloom this spring in the upcoming cases, but the fact remains that the DOMA case was not decided on the grounds of any personal right to same-sex marriage, but on the right of states to be free from federal intrusion into their policy decisions on marriage. Here is an argument that is agnostic on the underlying question of same-sex marriage. And this argument, too, has been brought before the court in numerous briefs. This is often referred to as the federalism argument. So, the justices know the arguments, or at least their clerks do. They also know the history. In the last decade or so, the people in 31 states have voted to define marriage as the union of a man and a woman in their state law. More recently, same-sex marriage was codified by 13 state legislatures. But now, judges are nullifying the votes of citizens. 23 states have been told their laws are unacceptable. Now, courts and commissions are telling us our beliefs about the meaning of marriage will not be tolerated. Now, owners of a family pizza parlor are receiving death threats for answering in the wrong way to a hypothetical question posed by a reporter on the issue of marriage. When the court convenes, it will be urged to settle the matter by mandating same-sex marriage nationwide. It's difficult not to think of Roe v. Wade. At the time of Roe, the abortion lobby was making gains. Some states were being persuaded to loosen their abortion regulations and limits. Not all would, to be sure. But momentum was on the side of the abortion lobby. But then the Supreme Court took the issue out of the hands of the people and dictated a one-size-fits-all response. They chose one side as the winner and mandated abortion nationwide with virtually no legal limits permitted. Now, the New York Times declared the contentious issue settled. And of course, there is hardly a less settled issue in American politics today. Deciding for a people disenfranchises them, embitters them, and ultimately does not persuade. The citizens of a republic can understand political wins and losses, and when arrived at democratically, even losses go down more easily. Losses do not go down easily when they are issued from powers on high. What happens after the Supreme Court rules on the definition of marriage is the subject of our panel today. I am pleased to bring you Attorney Jean Scheer, who the Legal Times described as a veteran Supreme Court and appellate advocate. For many years, Mr. Scheer worked at the prestigious law firm of Winston & Strawn, where he was a partner and chair of the appellate and criminal motions practice. He left in 2014 in order to provide legal defense for Utah's man-woman marriage law. Mr. Scheer graduated from Yale Law School and was a Supreme Court clerk to Chief Justice Warren Burger and Antonin Scalia. Following Mr. Scheer, we will hear from Professor Paul Sullins, a social science researcher and associate professor at the Catholic University of America. Dr. Sullins' research focuses on the application of quantitative methods to questions of cultural import, including the relationship between social and legal policy and Christian ethics. Rounding out our panel will be Mr. John Henry Weston, co-founder and editor-in-chief of LifeSite News, a daily news website on life and family that is an indispensable resource to all who work in this area, many in this room, myself included. Mr. Weston has authored numerous articles on marriage and family and has spoken around the world on the importance of marriage. And now, Attorney Gene Scheer.
Thank you, Kathy, for that introduction and for that excellent overview of our subject today. One of the things that I have done since losing the Utah case, and I hope that'll be reversed by the Supreme Court in the case that they're about to hear, but one of the things that I have done during the interim is to organize a group of 100 marriage scholars who came together to try to answer the question, what is the harm from recognizing same-sex marriage? And that ended up being put before the Supreme Court in the form of an amicus brief. And I also had a significant role in coordinating a number of the amicus briefs that were filed in the court, and I'm happy to answer anyone's questions about that effort. I like Kathy's invocation of Roe versus Wade because I think it's a good analogy to what the Supreme Court is being asked to do here. I also think another analogy actually is Dred Scott versus Sanford, and I don't know how many of you are familiar with that case, but that was another situation 150 years ago where the Supreme Court succumbed to the temptation to try to decide and resolve a divisive issue. And Dred Scott is another example of how those kinds of efforts by the Supreme Court tend to turn out very badly. They tend to backfire. If you go back to the history of Dred Scott, the Chief Justice at the time was Roger Taney from my state of Maryland, and he was very concerned about the division in the country over slavery, and he thought that this case that had come before the court was going to be an opportunity to resolve that question for once and all, and to reduce the division. And so he persuaded his fellow justices to adopt what was a very tenuous constitutional theory in an attempt to solve that question. As you may recall, what the court held in Dred Scott is that the federal government was without power to ban slavery in the territories. Okay, and that was a big issue in Congress at the time. Was could and would Congress ban slavery in the territories? And that was a big source of friction between the North and the South. So Roger Taney thought, well, we'll just resolve this in a legal case. And the implication of that ruling, of course, was that the states also lacked the power to ban slavery in their own jurisdictions, at least insofar as slaves being imported from southern states was concerned. The logical implication of his ruling was that if somebody moved from South Carolina to Massachusetts and they owned slaves, Massachusetts had no ability to tell that person, you can't own slaves in our state. And so as a political matter, that ruling backfired spectacularly, and most historians say that it was that ruling that at least contributed to the Civil War. Now, I don't mean to compare same-sex marriage to slavery, and I'm sure Kathy doesn't mean to compare same-sex marriage to abortion. But the point is, the political impact, the unexpected political impact of a decision by the Supreme Court that takes a very difficult and divisive issue away from the people and seeks to resolve it as a matter of constitutional law. Now, as a constitutional matter, the claims in these cases, the claims to a constitutional right to same-sex marriage is really at bottom a policy argument in search of a constitutional theory. And Dr. Sullins is going to explain to us in a moment why the policy argument is just wrong for some reasons that are pretty surprising. And Dr. Sullins has done some very important research that was not available and therefore not before the Supreme Court the last time they addressed this issue in Windsor. And I think his research has the potential to really undermine the emotional appeal of the advocates for same-sex marriage. So you'll want to pay close attention to what he has to say. What I'm going to do, and I don't want to preempt his discussion at all, so I'm just going to focus on why the advocates' constitutional theories are misguided. And one indication that their constitutional arguments are wrong is that even among the 4 or 5 federal circuit courts that have addressed this issue and have held that there is a constitutional right to same-sex marriage, they can't agree on a constitutional theory. And so if it were so obviously a constitutional right, you would think that the smartest federal appeals court judges would be able to see it and recognize it and agree on why exactly there's a constitutional right to same-sex marriage. The overarching question before the court, as you know, is not whether an exclusively male-female marriage policy is best, but whether it's allowed by the Constitution. And the court has divided the issue up into 2. And they've allotted separate argument time for these 2 questions. The first question is whether a state has the constitutional authority to define marriage as being between just a man and a woman for purposes of licensing marriages within that state. And the second and separate question is whether a state is constitutionally required, regardless of the answer to the first question, whether it's required to recognize same-sex marriages that occur in other states, and what does the state do with those marriages when the couple moves to the new state. So the court has allotted an hour and a half for the first and critical question and an hour on that second question, or what's sometimes called the recognition question. But the constitutional arguments on both of those questions are really essentially the same. So Judge Sutton, who wrote the opinion for the Sixth Circuit that the Supreme Court is going to be reviewing, did a very nice job of just kind of canvassing the various arguments and explaining why those arguments don't make sense, and he did it in a very nice way that didn't really indicate any view one way or another as to whether he personally favors same-sex marriage or not. And I think that was very wise on his part, because that's really the kind of opinion we would ultimately want to get from the Supreme Court. We don't want the Supreme Court to tell us whether same-sex marriage is a good idea or a bad idea. That's for us to decide. So Judge Sutton wrote just a very measured opinion that, without conveying any personal view on the issue, just explained why the arguments are wrong. One of the things he addressed was the original meaning of the 14th Amendment. And I can tell you that nobody has advanced a serious argument as to why the 14th Amendment, as it was originally drafted and understood, would require same-sex marriage. There are 2 provisions that the other side invokes. One is the Due Process Clause of the 14th Amendment that says the states can't deprive people of due process of law, or they can't deprive people of their liberty or their property without due process of law. And the other, of course, is the Equal Protection Clause. Well, if you put yourself in the position of somebody who voted for the 14th Amendment back in the 1870s, or whenever it was, they would not have understood the Due Process Clause to require same-sex marriage, of course. In fact, they had just fought a big political battle over polygamy and had decided that polygamy was not going to be allowed in the territories. And so if there were a right to same-sex marriage by virtue of the Due Process Clause, that would also have to mean that there were a right to polygamy. So they would have found it ridiculous to suggest that the due process portion of the 14th Amendment required same-sex marriage. And the same is true of the Equal Protection Clause. Even if you accept the proposition that gays and lesbians constitute a suspect class, and therefore that any law that impinges on their interests or discriminates against them has to be subjected to what's called strict scrutiny under the Constitution, the reality is that the man-woman definition of marriage simply does not discriminate on the basis of sexual orientation. There's no question on an application for a marriage license. Are you gay or lesbian, or are you straight? That's just not an issue. If you're willing to enter into the institution of marriage as it's offered to you by the state, you're able to do that regardless of your sexual orientation. And in fact, there are people who consider themselves gays and lesbians who nevertheless decide to get married to somebody the opposite sex. And in fact, there's one of the amicus briefs before the court right now was written by, it was an effort led by Doug Manwaring, who may be known to some of you here, but it was filed on behalf of 12 gay men and their wives, and they explain how that arrangement works, and they explain that even for them, considering themselves gay, the opportunity to participate in a traditional marriage, a traditional man-woman marriage, is very meaningful. It's something that they've been allowed to do. The state allowed them to get married, and most or all of these men have had children with their wives, and they basically describe how happy their lives have been as a result of their choice, even as gay men, to marry a woman and have children together in a traditional marriage. So there is no discrimination on the basis of sexual orientation. The mere fact that there's some people who have romantic relationships that they would like to have recognized as marriages doesn't mean that the state's required to change the definition of marriage to accommodate more romantic pairings. The fact is, the state offers the institution of marriage to anybody who's willing to accept it, regardless of their sexual orientation. Now, Kathy mentioned the Windsor opinion, and that's one of the main arguments that the other side makes, is that based on some language in Windsor about the importance of affording dignity to gays and lesbians and to their relationships, that should be a basis. That dignity interest, as it's sometimes called, should be a basis for recognizing a right to marry somebody of the same sex. But in fact, if you read Justice Kennedy's majority opinion in the Windsor case, every time he talks about this dignity interest of same-sex couples, he makes clear that the reason that the way that dignity interest arose was not from the ether. That dignity interest, according to the Windsor opinion, is based on state law. It's the state that has created that dignity interest, and given that the state had created that dignity interest, Justice Kennedy held, the federal government has no power to override that interest that is created by state law. So it's a little bit like, it's a little bit like a taking. I don't know how many of you are familiar with the takings clause of the Fifth Amendment and the 14th Amendment, but everybody knows, of course, that property rights are created by state law. Typically not by federal law, but yet there's a provision of the federal Constitution that prohibits the federal government from taking property. So the Windsor opinion is very much like a takings analysis, where if state law has created a certain kind of right, the federal government is powerless to simply take that right away. And so, again, as Kathy pointed out so well, if you really follow the logic of the Windsor decision, there's no way that the Supreme Court could force the states now to adopt same-sex marriage, because the whole premise of the Windsor opinion was deference to state authority over marriage. So it would be a monumental act of judicial hypocrisy now to turn Windsor around and to say, well, that means that states have to recognize same-sex marriages. There's just no way that decision would be consistent with the underlying logic of Windsor. Now, since the 14th Amendment was adopted, of course, there's been a lot of water under the bridge in terms of the development of the law, and there has arisen in the Supreme Court's jurisprudence a doctrine called fundamental rights, and that doctrine says that if there is a fundamental right to do something, then neither the federal government nor the states can deprive somebody of that fundamental right without really, really good reasons. Okay, and the court has recognized marriage as a fundamental right. And the other side makes a lot of those cases, cases involving, for example, prisoners who were told by the prisons, we're not going to let you get married as long as you're in prison. And there's a decision from the Supreme Court that said, no, there's a fundamental right to marry, and unless the prison has super good reasons for denying even prisoners that right, they have a constitutional right to marry. And the other side likes to draw an analogy to that case. Well, the problem with that argument is that every time the Supreme Court has talked about a fundamental right to marry, it has always been in the context of man-woman marriage. In fact, in many of those decisions, the court has said, well, marriage is a fundamental right because it allows a man and a woman to procreate together. So how can you possibly claim now that the fundamental right they were talking about is a right that involves a couple that by their nature are not going to be able to procreate together? And as to the other side's equal protection arguments, we already talked about the argument that that the man-woman definition of marriage discriminates on the basis of sexual orientation and why that's wrong. There's also another argument that has gotten some currency in some circles that the man-woman definition of marriage discriminates on the basis of sex. Because if I'm a woman and I want to marry another woman, the only reason I can't marry her is because of her sex, because she's a woman. If I wanted to marry a man, I would be allowed to do that. And so the argument goes that's improper discrimination on the basis of sex. But again, the hole in that argument is that sex discrimination, according to longstanding Supreme Court doctrine, sex discrimination only exists if men and women as a class are treated differently. But in fact, the man-woman definition of marriage doesn't treat women as a class any differently than men. It says to a woman, if you want to get married, you need to choose somebody of the opposite sex. And it says to men, if you want to marry, you've got to choose somebody of the opposite sex as well. So there's no class-based discrimination against either women or men. Now, there are also a couple of decisions out there that have ruled that the man-woman definition of marriage doesn't pass muster under the Constitution because there's no rational basis for it. And we could talk for a long time about why there is, in fact, plenty of rational basis for marriage, and Dr. Sullins may touch on that. But really, the opinions that have come to that conclusion, they've relied on things like the fact that states allow infertile couples to marry, and they say, well, if you were really serious about the procreative rationale for man-woman marriage, then you would have to exclude infertile couples from marrying. But one of the problems with that is that, of course, you can't really tell whether a couple is infertile without doing some very, very intrusive things. I mean, the only way you can tell for sure if a couple is infertile is to see if they can actually conceive a child together. But the whole purpose of marriage is to be sure that, or at least to increase the likelihood that people will choose not to conceive children until after they're married. And so you could try to test to see if people were infertile or not, but that would defeat the whole purpose of having one of the main purposes of man-woman marriage. Well, with that, I'll just close where I began, which is that if you think about each of the constitutional arguments that have been advanced in favor of same-sex marriage, each of them has an obvious hole in it, and so really for the Supreme Court to impose same-sex marriage on the states and to take that opportunity away from the people to decide that issue for themselves. If the court were to do that, it would be an act of judicial will and not an act of judging. I'll close there. Thank you.
Thank you. Dr. Sullins.
Thank you very much. Is this on? Yep. I'm a social science researcher. I'm not an attorney, although I've read a lot of briefs in the last 6 weeks or so. And one thing I have learned is that in legal circles, the word brief doesn't mean brief. They are long and complicated documents. So I'm just going to try to summarize very briefly as best I can. And it would help me by doing this. If you would just take a piece of paper, if you have a pen, I want you to write down 5 numbers. On one line, write the number 7, and next to it the number 17. And on the line below that, write the number 4 and the number 10 and the number 20. And I'll get back to that in just a couple of minutes. I don't know what you think of the late Senator Moynihan, but he said a really wonderful thing. He said, everyone's entitled to their own opinion, but they're not entitled to their own facts. And so my role in this setting and debate is, I think, to inject some facts into it, because there are a lot of myths and misconceptions that have been presented as fact, which just ain't so. The first of those is that there's no difference in outcome between children that are raised with parents of the opposite sex and parents of the same sex. Now, the reason that myth has been promulgated is because there's a series of studies, maybe 50 to 70, depending on who's doing the counting, that claim to come up with that outcome. But I went through and examined those studies, and of them, and other people have also examined them much more intently than I, of those studies, there are about 8 of them that are based on what we would call a representative sample. That is a sample that if there were differences between those children, it would be able to find them. And so the vast majority of those studies are biased. They are based on very small samples. The average sample size is 39 cases, which is not hardly any. And they're not drawn randomly. They're drawn from your gay advocate-oriented researcher going down to the local gay bar, the gay community organization, or advertising in the Gay Blade or similar paper, saying, "Come help us with this study." And then that's presented as if it's objective information. It's not. It's bunk. It would be like me going down to my local evangelical church or Catholic church and saying, "Let's do a sample and we can show how bad things are without having 2 parents," or something like that. And that would be just as unbelievable, because it's a already committed group of people. So what I have done is to show that those studies purporting to give those findings are really not credible. Now, of those 8 that are drawn on representative samples, the most recent 4 studies all show harm, substantial harm, to children that are raised with same-sex parents. Now, getting to those numbers that you wrote down, 7 and 17, that's based on the 3rd of those 4 recent studies, which I did. And that's the rate of emotional problems that are evident, comparing children that are with opposite-sex parents to children that are with same-sex parents. The 7%, the opposite sex, the 17% with same sex. So the rate of emotional problems is over twice as high overall if you have parents of the same sex. Now, that doesn't distinguish between whether it's married parents, whether they're 2 biological parents. It just distinguishes overall all the different kinds of families that we call families with opposite-sex parents. And if you go on and make that distinction, which I do in that study, you come to the second set of numbers. I'm basing these numbers on the National Health Interview Survey. And those of you who are interested in more detail, which I'm not going to go into here for sake of time, can look at the studies and find out more about it. All of the studies are posted on a really great website. It's called marri.us. It's related to the Family Research Council, a great organization you may have heard of, and they make it freely available. And I'd encourage you, if you want a lot more detail, to go into that. It goes into the measures that are used, which are the best measures in the world for emotional problems. And the data comes from the Centers for Disease Control. They've been collecting these data. You may know the government collects data on us. And so it's 100,000 cases they've been collecting since 1957 to predict health outcomes in the U.S. population. So it's probably the best data, best public health data in the world. One of the things the other side will say is that, we have dozens and dozens of studies that show no difference, and you have 1 or 2 studies that show difference. Why should we believe your study instead of our studies? I've given you the first important reason to do that, and that's because my study and the other ones like it are based on representative, random, non-biased samples. But the other reason is that the other studies are biased, and they would want you to think that the more biased studies you have, the closer you get as an approximation to the truth. But in fact, it's just the opposite. Have you ever gone to a party and played that game where they whisper something in somebody's ear and then they whisper it in somebody else? I think it's called gossip, and you go down the line. What happens to that information as you go down the line? Does it get more accurate or does it get less accurate? It gets less accurate. By the time the last person reports it, it has almost no connection to what came before. And that's the character of this so-called research that's being presented as fact by the other side. The other thing I want to mention is two other myths. One, that marriage will improve things for these children with same-sex parents. Maybe there are some problems, but if they got married, then outcomes would improve just like they do for persons in opposite-sex marriages. The most recent study, which is also posted there, is called The Unexpected Harm of Same-Sex Marriage. And it compares two groups of same-sex parents, one unmarried, the other married. And the harm is much greater for the children that are with the married parents than with the unmarried parents. Also, the children with the married parents have been in those settings an average of 10 years, with the unmarried parents an average of 4 years. And so that rebuts another claim, which is that, well, if we could get more stable families, if same-sex couples could marry, their relationships would be more stable, and therefore the outcomes would be better. But in fact, those children that are with stable same-sex parents who are married come out much worse than those who are with more recently formed same-sex partnerships where the parents are not married. And I think the reason the latter group comes out better is because they've had the experience of a heterosexual family prior to a divorce, most of them, and that actually produces better outcomes. The second set of numbers there, the 4, 10, and 20, is also relevant to this, and this is what I'll close with. On the National Health Interview Survey, they do a wonderful thing. They assess the biological relationship of each partner in the marriage or the partnership to each child. So for each child, you can tell whether they're living with both of their biological parents or only one of their biological parents or neither of their biological parents. And those are those three numbers, 4, 10, and 20. That's the rate of emotional problems for children in each of those settings. Now, these aren't married parents necessarily. They're joint biological parents. But about 90% of parents in that category are in fact married. Marriage is, you might say, a social arrangement to try to get joint biological parents to care for their children that they produce together. And so what that set of numbers underscores definitively, in my opinion, is that the best case for children is to be raised by their own parents, the two people who jointly produce them, almost always in an intact marriage. The second number are those children who are in some sort of failed marriage arrangement. They're living with one parent and a step-parent. And you can see that emotional problems almost more than doubles in that setting. And then if they're with neither parent, now that's mostly adopted children, but there are also some other arrangements like living with grandparents or other relatives. The emotional problems double again. And if you think about that second set of three numbers, you have the answer to why children will never do as well with same-sex parents as they will with opposite-sex parents. Because at least 2/3 of children in America are in that first category, the 4% category. So that brings the average reported in the line above that way down. Guess how many children of same-sex parents are living with both of their biological parents? Now, you might know that answer just by thinking about it in terms of human biology, or you might know it from religious conviction. But I have the honor to report to you the empirical finding from 1.6 million cases of the National Health Interview Survey on which not a single set of same-sex partners have been associated with a child that is the joint biological product of them. Now, some people, question whether that's important. But I'm telling you, if you didn't know it before, I can tell you on the basis of data, there are none. And so that's why those outcomes are higher. The children with same-sex parents are divided between the 10 and the 20 group. They'll never get into the group where there's only 4. So, if you had the choice where you could be born in this life, which one of those categories would you want to choose to be born in? Which one should we preserve as a right for children to have, and all of those issues that go along with that. Thank you very much.
Mr. John Henry Weston.
Thank you, Kathy. It is a pleasure and honor to be here among these very distinguished colleagues. LifeSite News is a news service that operates all around the world. We have been following this marriage issue because we report on life, faith, family, and freedom, but we've been following the marriage battle now for some 20 years. We've followed it in many, many countries around the world. And I'm going to give you a little bit of a different presentation from what we've heard thus far, because I'm going to go to where the arguments started and where they've ended up and what has happened. Where this started actually is not about marriage. We were receiving information early on in the marriage fight all over the world about the marriage fight. It wasn't considered anything in the 90s. In fact, if you look in the late 90s, you'll find the homosexual activists themselves arguing about the want for marriage. The typical argument was, why would we want an institution that is about monogamous relationships forever? That's insane. And if you know anything about the gay community, you'll know that their rate of monogamy approaches zero. And so they wondered, the activists themselves, I'm not talking just your average person with same-sex attraction in the street, I'm talking the activists themselves arguing amongst themselves, why would we go for marriage? But it was very interesting, the answer. The answer was because we need societal approval for our same-sex relationships. And it was the sexuality in the relationships that made them somewhat special, somewhat unique. Why? Because there's all sorts of same-sex relationships. We're encouraged. They're encouraged by the faith. They're encouraged by every form of civilized culture. Same-sex relationships are great, but not sexual relationships. Not sexual same-sex relationships. And what is the need for this? Why is this so? Well, if you're from a Christian persuasion, but even from a persuasion of natural law, you know that when you're doing things that you shouldn't be doing, it's hurting you. You get guilt, but you also get harm to your bodies, because if you're Christian, you believe God made your bodies. And if you're not even, you know that from the empirical evidence that you get, there are certain activities that are harmful. And so this is the way the debate went in the beginning. The argument, though, won over that we need this for a societal stamp of approval. And they got there. Obviously, in many countries around the world, this happened. In fact, in Canada, this same-sex marriage passed in 2005. My colleague Steve Jelsovac and I were asked at the time to sit on an advisory board to the Ontario Bishops' Conference, that's the Catholic Bishops of Ontario, into how to deal with this. We were dealing with it in 2004, and it was going to be a year or so out before we would have the eventual passage of the law. Very interestingly, what was said at the meeting was this. We presented, look, we've been following this issue now for some 10 years or more, and we can tell you that this really isn't that much about marriage as it is about homosexuality, homosexual sex. And so really what needs to happen, now we're talking to bishops, is the church, the Catholic Church, the Christian leadership has to stop its silence, because literally we've had silence on this issue for about 50 years. And what has happened is a massive disconnect between the pew sitters and those who actually know what the faith teaches, because the faith actually teaches nothing about hatred toward gays and lesbians. In fact, the opposite. But it also says that the behavior is damaging and harmful to your eternal salvation. That's the faith teaching. But they also know from the empirical evidence that the behavior is damaging to your body as well. If you look at it from that perspective, though, that's a perspective of love, not hatred at all. When you are parents and you deal with your children who are misbehaving, you correct them. Why? Not because you hate them, because you love them. What if they complain? You still correct them because you love them, because that complaint you will bear, you will take it because you know you're doing the best for them. And so with the same-sex marriage argument, we have the exact same thing. And yet, it's the argument that we never present. Not even from our religious leadership. In the beginning, the question is always between How come if these two guys love each other, they can't get married? And if we can't answer that question with love, we're going to be in trouble because love trumps almost every argument. So the answer back is quite simple. Hey, we love you enough to tell you that this is harmful. In fact, we'll even take the hater and bigot label so that we can tell you this because we care about you. And the reason why in the court they talk about this, they talk about it in terms of what they call animus. Animus comes from animosity, where we get a hatred towards somebody or a feeling of ill will toward them. And this was the famous distinction that has always been fought from the beginning. In Christian culture, we always had this saying, you love the sinner and you hate the sin. That distinction has been fought from the time this sort of war, if you will, began, because they want intentional confusion in that aspect. And it's in the courts as well. The courts are suggesting that there is an animus on the part of those who are opposed to same-sex marriage towards people who are same-sex attracted. And nothing could be further from the truth. Yes, I'm sure that exists in a few people, but the motivation from all of the faith groups, which are the majority that are fighting for traditional marriage, their position is one of animus against what? Animus against a behavior that is so incredibly harmful for the individual. And so the reason why this will play out in the future is because you can see what happens in the end. As I said, Canada passed same-sex marriage in 2005. And you always think, like Kathy was saying originally with the abortion decision, Roe decision, now we'll have cultural peace. There's no cultural peace at all. In fact, you find an increase in exactly what you're already experiencing that we saw with the RIFLA laws in Indiana, this great animosity toward normal Christian belief. But what comes down the road even after that is the same pursuit, this pursuit of needing to eliminate any kind of thinking badly about same-sex behavior. And it comes to us, to our children. The imposition of sex education that teaches homosexuality as right, normal, good, and wonderful in Canada should be a lesson for all Americans. The same thing is going on in Europe. Parents forbidden from excusing their children from these classes, and the courts determining that this shall be in schools, and not just public schools. It shall be in Catholic schools, in Christian schools, and in the province of Quebec, even in homeschooling. So this is where we're headed. And the reason why we need to focus on the love argument is because once you're beyond marriage and you're into that new imposition, if they think of you as just bigots, like racists, because you're against a class of people because you don't believe in their dignity, they will have no reason not to, as Cardinal George would say, make us die in our prisons. And I think we need to revisit this teaching, mostly from our pulpits, of our own love and concern for our brothers and sisters who are same-sex attracted. Because we have to show our reason for being here, our reason for doing this is an altruistic reason. Because without that, they will say, look at the bigots, and we need to be, we need to just quell this dissent. And let me just conclude with the words. Many, all over the world, when I speak on these issues, there are very many people who take the science and say it's wrong, it's biased. They're all anti-gay scientists who said that there's all these harms with same-sex behavior. And aren't there just as many harms with, heterosexual behavior and so on and so forth? And we argue a little bit about studies, but eventually you just can't do that anymore. And there was a very interesting thing, and I'll conclude with this, that happened in Canada in 2006, the year after same-sex marriage was passed. One of the Canadian gay activist leaders, who, by the way, died a couple years ago at 66 years old, which is very typical, early death, that is. He made a presentation before government asking for extra health care dollars for LGBT Canadians. And I'm going to read you his words. They are some of the most powerful words convicting me and anyone who cares enough about our brothers and sisters who are in these damaging relationships to strive to encourage them not to go there. And if you're Christian, the reasons are even more. They're eternal. And here are the words of Jens Hellquist, who was the director of the Canadian Rainbow Health Coalition. We have, he said, one of the poorest health statuses in this country. Health issues affecting queer Canadians include lower life expectancy than the average Canadian, suicide, higher rates of substance abuse, depression, inadequate access to care, and HIV/AIDS. He said there are all kinds of health issues that are endemic to our community. We have higher rates of anal cancer in the gay male community. Lesbians have higher rates of breast cancer. And then he concluded with these words. Now that we can get married, everyone assumes that we don't have any issues anymore. A lot of the deaths that occur in our community are hidden. We don't see them. And those of us who are working on the front lines see them. And I'm tired of watching my community die. Thank you for your time.
Thank you so much for all of those presentations. John Henry mentioned Cardinal George. I think it might be appropriate for me to say a word about this great defender of marriage and religious freedom who we lost last week, Cardinal George of Chicago, who faced fierce and unrelenting opposition, public opposition, but never stopped proclaiming the truth about the human person or the meaning of marriage. And his warnings, of which there were many, about the threat of radical secularization in our society and around the world. And I'd just like to tell you the quote, which is haunting now that he is gone, that John Henry mentioned, and then I'll ask the first question. A few years ago, he was speaking to a group of priests, and he made a bracing prediction. He said, "I expect to die in bed. My successor will die in prison, and his successor will die a martyr in the public square. His successor will pick up the shards of a ruined society and slowly help rebuild civilization as the church has so often done in human history." So I'd like to invite the panelists to make their own predictions. How will the case come down? And if same-sex marriage is mandated nationwide, will religious believers be permitted any sort of meaningful dissent? So, open to anybody.
Well, I won't predict how the case will come down. I will say that I think the arguments in favor of a constitutional right to marriage are very weak, and and if the court follows the law, it should be a very easy case for them. And if they do that, we'll win.
It's a big if.
But I think whether we win the marriage case, I think people who believe in traditional marriage are going to continue to be subjected to all kinds of efforts to curtail their religious freedom. I mean, there certainly is a culture war going on in our country right now, and much of it concerns sexuality of one kind or another, and it's not just the LGBT community. It's the whole secularized view of sexuality, and that camp is kind of at war with the people who have religious and other reasons for believing that sexuality has a purpose more than physical pleasure.
Mm-hmm. Okay. Any other responses?
Just that I tend to agree with Cardinal George's assessment, because having watched what is happening all around the world, seeing it in Canada, in Europe, and increasingly so in the United States as well, there is a crackdown on religious freedom coming. It was seen a long time ago as well. I'm going to quote for you Cardinal Ratzinger, and this is Cardinal Ratzinger 18 days prior to his election to the pontificate, 1 day prior to the death of Pope John Paul II. He said, "Very soon it will not be possible to state that homosexuality, as the Catholic Church teaches, is an objective disorder in the structuring of human existence." I have to say, I do believe the times are coming where America will experience a new round of Christian persecution. And that's, I can't see it any other way right now. Our trajectory is in that direction. I pray it doesn't go there.
I have no idea. There's an empirical researcher for you. I've asked the same question of other people, and the estimates, the highest estimate is 50-50. And the lowest one is it's like spitting into a hurricane to try to oppose this action. So I have no idea myself.
Do we have any questions from the audience? And raise your hand and we'll have a mic come your way. And even though I know you, please identify yourself.
Hi, I'm Peter LaBarber with Americans for Truth About Homosexuality. And John Henry, first of all, thank you for LifeSite. I think it's probably the finest pro-family website in the world. I'm very amazed and at the ease with which you bring the discussion back to behavior. And I think part of the problem with the marriage discussion is in defending against gay marriage, even most pro-family advocates have tended to veer away from behavior, sort of in the sense that this is the way to win, and also out of a political correctness. And then now we've seen with the presidential aspirants, both Carson and Rubio now, sort of stumbling on the question of choice. My question is, how do we, it seems to me that people stumble over born gay and choice. If they think there's no choice in homosexuality, it's only a matter of time before they don't resist the public policy arguments of the homosexual activist side. And obviously everybody has a choice over which behaviors they practice of whatever persuasion. How do we return the discussion so that we do focus on behavior and that people are not defined or predestined towards this lifestyle?
One of the very first things is this argument must needs come from our religious leadership. It has been, honestly, 50 years without hearing it. We've heard, from some quarters that there's preaching on this a lot. There's not. When we heard that there was, pro-life leaders, pro-family leaders fall out of their chairs, where? Who's saying what? There just isn't. It has to be made. It has to be brought back. In my opinion, it has to be brought back to love, this understanding. But the actual thing about choice is very interesting because let's look at our own leadership on the other side. Most gay activists are come out, even legislators, they led the charge, but they're yes now with their homosexual partner, but oh, lo and behold, they had a previous marriage and actually children. There's something strange about that, because if you believe there's no choice and this is a complete impossibility, then how do you have children? And so the rationale is on our side. We actually need to make the voice, give it voice, and it's been sorely lacking.
Could I respond to that? Though I think actually it's useful and important to keep the question of marriage separate from the question of behavior, and that is, there are a lot of reasons for that. For one thing, a lot of our fellow citizens, have different views about homosexual behavior, and if our case for traditional marriage also depends on any view about homosexual conduct, we're almost certain to lose politically, because we're unlikely to have a majority on that question today. But also, if you look back at history, for example, go back to Greek and Roman society, both of which not only condoned but even encouraged a good deal of homosexual sexual activity. Those societies vigorously protected man-woman marriage and vigorously limited man-woman marriage, vigorously limited marriage to a union of a man and woman, because they understood the importance, whatever one's views about sexuality, but the importance of having an institution that encourages men and women to get together and to stay together for the good of any children that might come from their unique sexual union. And so you don't have to believe that homosexual behavior is bad to recognize that that there is something unique about the sexual relationship between a man and a woman. And also, just to as far as litigating the marriage case before the Supreme Court is concerned, the Supreme Court has already held in a case called Lawrence, that I'm sure you're familiar with, that gays and lesbians have a constitutional right to engage in non-procreative sex together. And so if you argue for traditional marriage in a way that looks like you're fighting against that holding, then that's a losing legal strategy.
Now, may I just say, but as a cultural strategy, I think you're right, Peter, that if people think that this is non-chosen behavior, then why can we have moral objections to it? I mean, moral restrictions only apply to things that we choose to do. So I'll just say that in the scientific world, I know almost no scientist who thinks that there's any evidence that same-sex attraction is an innate or genetically encoded behavior. That argument probably at least 10 years ago was put to bed in favor of there being a combination of, genetic and environmental influences on that. So, when you say, is it chosen, it's tricky because there are lots of psychodynamic things that happen to us that are not chosen. And there are a lot of things in our lives that we think are chosen but aren't, and that we don't think are chosen but are, right? Like I talk to Catholic audiences, and people talk about being born Catholic, right? But I don't think there's a Catholic gene that makes that happen. But there's a strong, family influence there. So if you're interested, I do have a paper that gathers together the evidence on this, and it's really compelling. Like twin studies have found that there's almost no heritability, rate of heritability between siblings. If one sibling has same-sex attraction, there's almost no propensity for the other one to, unless they're raised in the same household. Also, there's a great fall off in homosexual practice. If you look at population surveys, by age 35, about 2/3 of those of males who report having sex only with men at age 18, 2/3 of them by age 35 are having sex only with women. So that it's not something that is appropriate to think of a genetic condition, like I don't know, let's say male pattern baldness. It just doesn't all of a sudden start reversing, because it's a genetic condition. I know, I'm sorry. I thought you could relate. So anyway.
We have a question in the front. Did the mic? Oh, I'm sorry. You're in charge. Good. Mic guy.
Hi, Dustin Siggins, DC correspondent for LifeSite News. Dr. Sullins, you mentioned the other side's studies are biased, and you said that your studies and people on our side are not biased. That is countercultural, if you will, to the media portrayal. Can you delve a little bit into that, why we should assume that people on our side are not biased in their studies and the other side is?
Sure. I wouldn't want to say that I'm biased or not biased, but the data that I'm using, I'm referring to the source of the evidence, right? And so the data that I'm using was collected by the Centers for Disease Control. It was not collected by any particular advocate of any position one way or another. So there's probably very low, to be fair, extremely low probability of selection bias in that data. And that's what I'm talking about. Now, the other side does use a couple of representative random samples, too, and I would not call them biased. Wainwright's studies, for example, don't use biased data. It's not a convenient sample. There are other problems with that study that I pointed out. So that's what I mean by that. In fact, the non-biased data are used by both sides. But the majority of the findings from the non-biased data show harm in various levels. Even the studies that claim not to show harm, if you go back and look at the distinctions that are made, there's harm there. So.
Hi, I'm Penny Starr with CNS News. There are a lot of briefs that are under this case that's coming up next week. But one that I thought you might comment on are by at least 4 individuals who filed briefs against same-sex marriage, and they were raised by either gay man or 2 lesbians, in other words, homosexual families, and they've said how damaging it was for them. Will that have any influence on what happens next week?
I think those briefs are helpful in that they serve to underline the key point here, which is that there's so many potentially bad effects of a Supreme Court decision mandating same-sex marriage throughout the country. There are just so many potentially bad effects of that it's a decision the court really ought to leave to the people to decide. And the kinds of heartache that's described in those briefs are just one example of a host of different potential harms that might come from that kind of a decision. And that really is one of the most important policy reasons why the court ought to leave these kinds of difficult, sensitive social questions to democracy. The court's not a legislature. The court doesn't have the ability to delve into those kinds of things to determine, well, exactly what kind of a policy can we establish that's going to maximize the benefits and minimize the harms.
What about the fact that you mentioned how many states, 23, I believe, have had judges override what the people have decided in states? How does that fit into the equation? Because a lot of states have said, we want marriage to be between a man and a woman. And then a judge says, no, this is unconstitutional to not allow same-sex marriage.
I'm not sure I understand. How will the upcoming case impact? Or
Even now it's being impacted. In other words,
right.
That's what
Even now it is being impacted. Of course, depending on how the Supreme Court goes, all of those rulings will be affected. So all of those rulings and all of those votes are being held in abeyance. They may have the power again, and if the court goes in the way against imposing same-sex marriage nationwide, I think, I didn't study this question. Maybe you did, Jean, but I think those laws would be in effect.
Yeah, that's correct.
Yeah.
Is that right?
I don't
Yeah,
think anything's happened to them, other they haven't repealed them.
Yeah, as a practical matter, now there will probably be some procedural wrangling in the states where those decisions have already become final. But as a practical matter, the end result of a Supreme Court decision holding there is no constitutional right to same-sex marriage, the practical effect of that ultimately will be to undo the federal court decisions that have ruled that there is a constitutional right. Now, a Supreme Court decision like that will not affect state court decisions that have ruled that under the state constitution there's a right to same-sex marriage. So Massachusetts wouldn't be affected, for example, and Iowa wouldn't be affected because those states have same-sex marriage as a result of rulings by their own state courts interpreting their own state constitutions. So those rulings wouldn't be affected.
And then isn't it also possible for a circuit split to remain? Is that possible at all at this point? Isn't there a third or fourth way the court could rule?
Well, there are a couple of different ways the court could rule that wouldn't resolve the circuit split. I suppose it's possible that one of the justices could decide to recuse himself or herself, in which case they might split 4-4, which wouldn't really decide the issue. There are also people who have argued that no federal court actually has jurisdiction to determine whether there's a constitutional right to same-sex marriage, and if the court were to adopt that argument, which is not it's not really being seriously pressed by any of the parties, but if the court were to adopt that argument, then the effect of that would be to nullify all of the lower federal court decisions that have gone the other way, and they would just say this is an issue that has to be decided in state court in the first instance, and then if the conflict bubbles back up to us, we'll decide it then.
And there's precedent for that.
There's precedent for that.
So if they ruled in support of the respondents, we would still have same-sex marriage in some places in this country. Is that right?
Not the last scenario.
No, if they rule in favor of the respondents, that is,
Yeah.
in favor of the states that are defending their laws, if the court unambiguously rules in their favor,
Yeah.
then that will have the effect of undoing the other federal court decisions that have gone
Right.
the other way.
Right.
So we would not have same-sex marriage as a result of federal court decisions.
Right, but you'd still have it as a result of some state decisions.
Yes,
Right,
sure.
so we would have a patchwork.
Yes.
Kind of just like you were referring to abortion before, or maybe in the absence of Roe v. Wade.
Right.
Right.
Other questions? There's.
Hi, I'm Doug Miles. I'm a Mercer County, New Jersey Republican committeeman. My question for the judge would be how likely you were a judge, sir, were you not once? Yeah. Okay. Apologies. How likely is it the court might get into the discussion, interpretation of, or commendation of civil unions as a remedy for the states?
I think it's unlikely that they will say much, if anything, about that, because none of the parties are really pressing that on them, and none of the couples that have sought a same-sex that have sought a constitutional right to same-sex marriage have said, you know, in the alternative, we think we should be entitled to something like a civil union. None of them have made that argument, and so it's unlikely the court would say anything about it.
What happened with those last two cases last year with the DOMA one and all, isn't it almost wishful thinking to think that the judges aren't going to say okay to gay marriage?
No, I don't think it's wishful thinking. I mean, the other side relies principally on the Windsor opinion, and we've already discussed earlier today why the Windsor opinion cuts very much in favor of the states that are defending their marriage laws. You know, and if you just look at how the Supreme Court justices have actually, to the extent they've written about this at all, as Judge Sutton pointed out in his opinion for the Sixth Circuit, there is not a single U.S. Supreme Court justice who has written an opinion saying, I think there's a constitutional right to same-sex marriage. There are 3 justices who have either written or joined opinions saying, I think there is no constitutional right to same-sex marriage. Justice Scalia, Justice Thomas, and Justice Alito, and Chief Justice Roberts is probably another. Is his opinion in Windsor? He dissented in Windsor, and his opinion strongly suggested that he does not think there's a constitutional right to same-sex marriage. He didn't say definitively what he thinks about it, but you know, if you count up the votes, on Tuesday morning, they're going to be walking into a situation where there are 3.5 justices who have said no constitutional right to same-sex marriage, and no justices who have said there is a constitutional right to same-sex marriage. And so if you just, you know, well, and not even she has.
She didn't say it like that.
Not even she has conclusively
ready.
said it, or
Right.
you know, or written that. So, you know, just based on the numbers, walking into the courtroom. It's hard to conclude that it's a foregone conclusion that the other side will win.
If we have time, there's a very intelligent-looking man over on the in the back who needs the mic.
My name is Austin Roos.
What's your affiliation?
Kathy is a judge. One of the more interesting developments in the world, two things. First of all, I'm president of CFAM. Folks are under the impression that the world is about to come to gay marriage. The United States is about to come to gay marriage. You know, we have to remember that most of the people are with us. We've won all these state elections. Overwhelmed. There's a very interesting brief by Cole Durham and Lynn Wardell and some others before the court that explains that only 17 countries have allowed same-sex marriage in the entire world. And only one of those was imposed by a court, and that's Brazil. So if these guys, you know, on the court who like to look for foreign sources, they can look at that. They can look at all those decisions of the European courts, international courts as well as national courts, to say there's no human right to same-sex marriage. Your comment?
You're exactly right. A decision imposing a constitutional right or recognizing a constitutional right to same-sex marriage would clearly put the United States out of step with the international mainstream, in Europe and everywhere else. You're right. Brazil is the only nation where same-sex marriage has been imposed as a result of judicial fiat.
Hi, my name is Matt Floyd. I'm the pastor of Calvary Bible Church in Westminster, Maryland. And I actually just preached on this a week and a half ago, preaching through Romans. And so my first thing is, yes, it is sin, but why should we care? Why should we say something about it? Is because we should love them more than anybody else. That's why we should be involved. Well, as a pastor who's looking to be involved and looking to, have a voice in the issue, one of the things I wanted to ask Mr. Shear, I believe, is before you had said something about separating marriage from behavior, and I'm just trying to figure out exactly what you mean by that. Because if we do that, would that lead to other things beside same-sex marriage? Polygamy, or even bestiality. You go on and on and on. If we separate the two, and also if we separate the two, I agree. I think that I should be aware of the court cases and different things, but that takes my voice out of it in a large part, because I want to focus on the behavior part and the results of that. So I'm just trying to in my mind, put that together, and how would I do both of those?
I think you can certainly do both of those, but I would just view them as separate efforts. I mean, the legal case in favor of man-woman marriage laws does not depend at all on any view that homosexuality is a sin or that it's harmful or anything like that. I mean, a lot of us have religious reasons for believing that those things are in fact true, and those things in some circumstances might lead us to be more favorably disposed to man-woman marriage laws. But the legal case for those laws does not depend at all on that. I mean, there are people with a wide variety of views on those issues who do not believe there's a constitutional right to same-sex marriage. And I would say also that the policy case for man-woman marriage laws does not depend on any view about homosexuality. I mean, for some people, those views may supplement, may give them an additional reason to be opposed to same-sex marriage, but for a lot of people, a lot of people think that there are strong and sufficient reasons to support man-woman marriage laws without also thinking that homosexual behavior is either sinful or harmful. And so I think to the extent that we want to be successful in the public square in persuading people to adhere to the man-woman definition of marriage, and again, if the Supreme Court rules in favor of the states, this whole issue of same-sex marriage is going to get thrown back to the states, right? So there are going to be a whole host of political battles. The marriage equality groups, they're going to pick off the states where they think they can win the political battles on that issue. And my own view is that if our side, and I consider myself certainly on the side of traditional marriage, my view is that if our side wants to win those political battles, we're going to need to, except for when we're in our churches, we're going to need a way to talk to people and persuade even people who don't believe in God at all, or people who may have religious beliefs but don't think there's anything wrong with homosexual behavior.
So you're saying that as a matter of legal strategy, you don't want to talk about the behavior, right? But not necessarily intrinsic to the issue itself.
Yeah, and I think as a matter of political strategy, I think it's also not helpful for our side to make it look like those two issues depend on each other.
May I inject a comment for the pastor? You're preaching through Romans, right? St. Paul in Romans also appeals not to religious tradition, but he says that the created order of the world is understood through the things that are made so that they are without excuse. And that's the basis for, in Christian theology, the distinction between special revelation, which comes straight from God, right? And you know this distinction, natural revelation, that comes through the order of the created world as God has made it. And so Christians have always made this double appeal. We're going to appeal to Holy Scripture for people who believe that, but if you don't believe that, you need reasons that come out of logic and rational discussion and argument and evidence. Then we'll give you reasons also, because both of them illustrate the same truth.
Absolutely. If I may, the one, I won't speak to the legal sphere because it's not my area, but definitely in the cultural sphere and political, because the culture affects the politics, we have to raise these issues, not just in our churches. What is wanted is that, by the powers that be, as it were, is that we sequester these discussions only into our churches. Absolutely not. We have to present, yes, we're not going to go out in the corner and say, because Jesus said so, which he did, but we're going to go out there and say, all the empirical evidence that we have supports this view of human sexuality. The only form of healthy human sexuality is the lifelong, faithful union of one man and one woman. And we have amazing empirical evidence today to show that, more than we've ever had before. Psychological evidence that shows you're indelibly connected to your first sexual partner for life, even if you have many more. So we have incredible research out there that should, can, and must be brought to the public square.
Rob Schwarzwalder with the Family Research Council, also a very intelligent man, Kathy. And thank you. Just wanted to clarify that. And Mr. Scher, if I may, probably the reason he called you judge is, has anyone ever told you bear a striking resemblance to John Ashcroft? I mean, it really is extraordinary. Frivolity all aside, I do have a serious question, and it relates to the research Dr. Sullins has done. As I've read probably more copiously in this field than I ever thought I would need to, one of the things that strikes me is that the research all indicate very clearly that a child does best with a female mother and a male father. That's quantifiable. It's hard data. And one of the frustrations I've had is in reading the responses of many in the legal community. It seems as though that argument does not resonate. And I'm wondering if you, Mr. Scher, if you could comment on that in terms of how potent you think that argument will be before the court and what the ramifications for ignoring that argument potentially are.
Well, I think it's one of the arguments that could well move some of the justices. To the extent that they want to look beyond just what the law requires, and and for that reason we actually have an amicus brief in addition to Dr. Sullins' brief. We have an amicus brief by several scholars of gender complementarity, who wrote what I think is just a beautiful brief. Describing really in layman's terms why it is that having a mom and a dad is so beneficial to children, and there's been a fair amount of writing on that subject just recently, and so I hope the court will look at it.
What are the names on that?
Janet Erickson is one of the principal authors. I think it's entitled Amicus Brief on behalf of scholars of gender complementarity in parenting. I think that's the title of it.
Well, unless there are any other questions, one more question.
Sorry to double down back to this issue of the behavior, but one, we've got the ex-gays who've overcome homosexual behavior, many of them, despite the concerted efforts of homosexual activists to sort of block that message from the public sphere. But it seems like between the two of you, Dr. Scher and on this side, there's a conflict here because, John, you were saying, John Henry, that one of the things we need to factor in is under a sort of the false egalitarianism posited by the gay side, everything's equal. Therefore, under a gay marriage regime, all children must be taught all types of sexual practices, meaning that little boys and girls must be taught various practices, which we shouldn't discuss here, in the interest of equality, because they may end up one day to be in a same-sex relationship, which by the leftist definition is completely equal to any other type of relationship. Therefore, don't we have to, I think one of the effective things we need to do in this equation is get people to understand that it's not just some abstract thing of two people in love, but it has real-life implications. Beyond religious liberty, also the teaching in our schools of this behavior, it would essentially mandate the teaching of the behavior to children. So I don't see how we only discuss that in churches. It seems like that's a public policy question, and I don't understand the logic of saying just this one public policy question must be left out, when certainly the gay side never restrains itself in any of its pursuits. It never blocks out and says, we won't discuss this. They completely advocate the teaching of sexuality as equal.
I don't know if that question was directed at me, but I'm not for a minute suggesting that we shouldn't talk about both subjects in the public square. I think we should. My practical suggestion, though, I mean, it's essential as part of the legal strategy, but my practical political suggestion, as one who's had some experience in the political realm on this issue too, is that our side, the pro-traditional marriage side, will do better if we keep those two issues separate in our discussion of them in the public square, and not talk about marriage as though the case for traditional marriage depends on any particular view about homosexuality.
In listening to the back and forth, what I am hearing is, and we're in the context now that we're days away from arguments on this particular case. This is the important thing before us right now. To win this case, we don't have to convince society or even 9 justices or even 5 justices to agree with us on the meaning and purpose of human sexuality. We frankly only have to convince them to agree with the agnostic argument, which is the states should continue to be the ones making marriage policy, not the federal government, whatever that marriage policy is. So that's a much easier argument to make and win than these other arguments, which need to be made and won eventually. But I think, it depends on what your particular aim is, and right now we're aiming at this case. So I don't see I don't see a disagreement. I just think, do you see what you agree? Yeah. Right. All right. Well, let me thank our panelists. Let's give a round of applause. Oh, I'm sorry. And perhaps some of them will be available to have further discussions afterwards, because now I see another hand. Thank you all for coming, and please come again to another lecture. Thanks.